In terms of the legal and regulatory framework concerning nuclear energy, we will first focus on the liability and compensation laws. Now, having experienced the consequences of the horrific bombings in Japan and knowing well that the traditional principles of state responsibility and liability may not suffice in respect of a nuclear accident, the Organization for Economic Cooperation and Development, or the OECD, established the Convention on Third Party Liability in the field of nuclear energy, also known as the Paris Convention, in 1960. This is a nuclear liability regime for most of Western Europe. Supplementing the Paris Convention, the 1963 Convention, supplementary to the Paris Convention of 29 July 1960, which is also known as the Brussels Supplementary Convention, was established to provide for enhanced compensation. The International Atomic Energy Agency sponsored an international regime in 1963, the Vienna Convention on Civil Liability for Nuclear Damage, also known as the Vienna Convention, largely on the principles laid down in the Paris Convention. The principles, which remain the bedrock of state responsibility and liability, are as follows. First is the no fault or absolute liability principle. The second one is the principle on legal channeling, which basically means that liability will be channeled exclusively to the operator of the nuclear installation. The third principle, which relates to exclusive jurisdiction, states that only courts of the state in which the nuclear accident occurs have jurisdiction. The fourth principle relates to limited liability and provides for a limitation of the amount of liability and the time for claiming damages. This is also the principle on limitation in time. Finally, the sixth principle states that the operator must secure insurance or financial guarantee to the extent of his liability amount. With both these conventions being independent of each other, it was open to states to adopt either of these conventions. This raised the issue of coordination and harmonization between the two conventions. After the Chernobyl nuclear accident in 1986, to rectify this problem, the two conventions were linked by the joint protocol relating to the application of the Vienna Convention and the Paris Convention, which came into force in 1992. Along with this, there was a complete revision of the Paris Convention and the Brussels Supplementary Convention. The 2004 protocol to amend the Paris Convention on third-party liability in the field of nuclear energy amended both the Paris Convention and the Brussels Convention. The Vienna Convention has also undergone significant changes. In 1997, over 80 states adopted a protocol to amend the 1963 Vienna Convention on Civil Liability for Nuclear Damage, which came into force in 2003. In addition to the Paris Convention and the Vienna Convention, at the insistence of the United States, the International Atomic Energy Agency sponsored another international nuclear liability regime, which is known as the Convention on Supplementary Compensation, or the Compensation Convention, in 1997. This convention is structured as an umbrella legislation. It provides additional amounts to be offered through contributions by the state parties on the basis of their installed nuclear capacity. However, the convention is still not in force. In India, the Civil Liability for Nuclear Damage Act of 2010 came into force on 11th November 2011. The law retains most of the established international principles, but it is argued that it deviates on two major contentious points. One is the right of recourse against suppliers in respect of who are covered and the extent of their liability, and second is the right of citizens under tort law to approach courts for claiming more compensation. These are yet to be settled. The Civil Liability for Nuclear Damage Rules 2011 have also been framed in respect of a few provisions, and they were notified on the same day along with the Act. In terms of the nuclear liability regimes, countries have established national regulatory institutions. Many institutions, like the United States Nuclear Regulatory Commission, started with promotional and regulatory duties together, but later changed to perform specific regulatory roles. Today, some of the efforts of the NRC are focused on reactor safety oversight, reactor license renewal of existing plants, materials safety oversight, materials licensing for a variety of purposes, and waste management of both high-level waste and low-level waste. In addition, the NRC is preparing to evaluate new applications for nuclear plants. Insofar as the Indian context is concerned, the Atomic Energy Act of 1962 envisages regulatory and safety requirements. The Atomic Energy Regulatory Board, or the AERB, is the regulatory body that lays down safety standards and rules and regulations in regard to the regulatory and safety requirements envisaged under the Atomic Energy Act of 1962. The AERB was constituted on 15th of November 1983 by the President of India by exercising the powers confirmed by the Atomic Energy Act to carry out certain regulatory and safety functions under the Act. The regulatory authority of the AERB is derived from the rules and notifications which are promulgated under the Atomic Energy Act and the Environment Protection Act of 1986. The AERB is currently structured under the Atomic Energy Commission, reporting to the chairman of the AEC. In order to provide independent legal status, the government has tabled a legislation called the Nuclear Safety Regulatory Authority Bill of 2010, also known as the NSRA Bill. When the bill becomes a law, there will be structural changes in the current AERB, and the bill says that the AERB may be subsumed under the NSRA bill. Insofar as the international framework is concerned, the IAEA on its part, taking forward the obligation under the statute, has been at the forefront of framing, collaborating, and disseminating standards of safety through its program, fundamental safety principles, safety requirements, and safety guides. These instruments reflect international consensus on what constitutes a high level of safety for the protection of people and the environment from harmful effects of ionizing radiation. As the primary publication in the IAEA Safety Standards series, the Fundamental Safety Principles establish the fundamental safety objectives and principles of protection and safety. They convey the basis and the rationale for the safety standards for persons at senior levels in government and regulatory bodies. The second publication, known as Safety Requirements, establishes the requirements that must be met to ensure the protection of people and the environment both now and in the future. These requirements are governed by the objectives and principles of the safety fundamentals. The format and style of the requirements facilitates their use by member states for the establishment in a harmonized manner of their national regulatory framework. The third publication, known as Safety Guides, provides recommendations and guidance on how to comply with the safety requirements, indicating an international consensus on the recommended measures. The safety guides present international good practices, and increasingly they reflect best practices to help users striving to achieve high levels of safety. Now, the standards, these three publications, are applicable throughout the entire lifetime of facilities and activities, both existing and new, which are utilized for peaceful purposes. It is also applicable to protective actions to reduce existing radiation risks. Now, 3 nuclear accidents: the 3 Mile Island nuclear accident in the United States in 1979, the Chernobyl incident in the former Soviet Union in 1986, and the nuclear fallout subsequent to the earthquake and tsunami in Japan in 2011 have exposed the nature of nuclear accidents and their possible impacts on humans and the environment. In addition, in the post-9/11 attacks in the United States, there has been heightened concern regarding the possibility of nuclear materials getting into the hands of terrorists. Governments the world over have taken a series of measures to counter this possibility. As a result, there are a host of international and national legal and institutional instruments in respect of nuclear energy production, its use, and safe disposal of waste. The list covers terrorism, securing safety of nuclear facilities, transboundary issues, transportation of nuclear materials, personnel working in nuclear facilities, their safety and security, export and import of nuclear materials, management and safe disposal of nuclear waste, decommissioning, etc. In order to share valuable regulatory experience on safety, the Convention on Nuclear Safety was adopted in Vienna on 17th of June 1994 under the auspices of the International Atomic Energy Agency. The objective of this convention is to legally commit participating states operating land-based nuclear power plants to maintain a high level of safety by setting international benchmarks to which states would subscribe. The obligations of the parties to the convention are based to a large extent on the principles contained in the IAEA Safety Fundamentals document called Fundamental Safety Principles. These obligations cover, for instance, siting, design, construction, operation, availability of adequate financial and human resources, assessment and verification of safety, quality assurance, and emergency preparedness. Now, in summary, nuclear energy development has had a checkered history, both as a technological sensation and in terms of its risks. In terms of a technological sensation, nuclear energy has the potential for energy production and has great medical and agriculture benefits to offer. In terms of risks, we have been exposed to the human and environmental devastation resulting from a nuclear accident. Nuclear law covers legal instruments and institutions governing production and use of nuclear energy, but there is a need to allay fears through establishment of robust laws and institutions for regulation and protection of nuclear energy. There is also a need for more acceptance of the legal instruments relating to nuclear energy. Thank you very much.